Good evening, friends. Amongst us, we have Mr. Vishwanath Angadi, who has already done various sessions with us. We all know that he has been taking topics which are quite niche. That's why when we feel that the public at large has to be enlightened on certain aspects, we make a request to him. Today's topic is assessment of compensation for permanent disability in respect of a disability suffered by a minor and also in case of a death of a minor. What are the parameters under the Motor Vehicle Act? In the today's journey of legal sharing from Mr. Vishwanath Angadi, who hails from Bangalore and has been the principal district judge, I request to Mr. Angadi to take over the session.
Thank you, Mr. Vikas. Thank you, the viewers across various parts of our country, advocates, law students, and also others. The topic is very interesting in as much as we see in many cases the motor accident claims tribunals across the country, they award compensation for death of a minor of a given age, which ranges with a gap of around 2 lakhs or 3 lakhs. So my endeavor is to empower on the aspect of the case laws of the apex court, on the aspect of assessment of quantum of compensation in case of death of a minor in a motor vehicle accident. The second point is how to assess compensation in case of permanent disability of a minor in a motor vehicle accident. So before that, I will discuss what are the gray areas. The first one is how to assess compensation. What about yardsticks in case of death of a minor or injury caused to a minor which results in disability, the total or partial as the case may be. How to compute the income which the minor was earning as on the rate of accident or as on the rate of death. The question is, what about the amount of income which the tribunal must take into account while assessing the amount of compensation? Can the tribunal or the court lay hands on the schedule number 2 to the ME Act, which states that in a case where there is no income of any person, the court can lay its hand on the notional income of rupees 15,000 per annum and then go forward. So a coolie or a laborer having no income, in that case, the tribunal or the court may take into account the notional income at rupees 15,000 per annum. But under the same yardstick, the court can adopt in case of death of a minor or not. The second point is, can the court award on the head of future prospects of life in case of death of a minor in an accident or a minor suffering disability which is permanent, either partial or total is the important question. With these three important brief parameters in mind, I will just tell quickly how the range of award of compensation for death of a child of 10 years ranges from an amount of rupees 1.5 lakhs to rupees 5 lakhs. The range for death of a minor child of 10 years by the apex court ranges from 1.5 lakhs to 5 lakhs. So the difference is 3.5 lakhs in the age group in the case of death of a minor of age of 10 or 11. And I will just tell or unfold quickly the case laws of the apex court on these points. In the case of Meena Devi, the Supreme Court of India just last year for death of a child of 12 years, awarded rupees 5 lakhs. In the case of Kurwan Ansari of the last year decision, death of child of 7 years, the apex court awarded rupees 4.7 lakhs. In the case of Rajendra Singh, death of a child of 12 years, the award amount was 2.95 lakhs. In Kishan Gopal case of 2014, death of child of 10 years, the award was rupees 5 lakhs. In the case of National Insurance Company versus Kusum, death of a child in the womb, the Supreme Court awarded rupees 1.8 lakhs. See the glaring difference in award of quantum. In R.K. Malik case of the Apex Court of 2009, the award was rupees 3.05 lakhs for death of minors in the range of the age of 10 to 15 years. In the last case of Sajendra of the Supreme Court of India, death of 9-year-old child was awarded rupees 1.8 lakhs. So the range is death of child of 9 years or 10 years, starting from 1.8 lakhs up to rupees 5 lakhs is the range. My endeavor is how the advocates can empower the motor accident claims tribunals and see that they get for their client or clients the compensation which is just, fair, and reasonable. As regards a case of permanent disability, we got some cases of the apex court of recent origin. In case of 100% disability of a minor boy of 5 years studying in upper kindergarten, the apex court took into account as a case of 100% disability and awarded 21.6 lakhs as compensation. On what grounds or on what heads the apex court granted various heads of compensation to award the amount of rupees 20.6 lakhs. In the case of Kajal, the apex court in 2 years ago for disability of a child of 12 years, a female child of 12 years, having 100% disability, the Supreme Court awarded 62.27 lakhs as compensation. So disability of 100%, depending on the fact of the case, the apex court in Kajal case awarded 62.27 lakhs as compensation. I will not take much of the time here. I will now go quickly with some of the important case laws of the apex court, which I just highlighted. I will tell on what heads the court must award compensation. What to be pleaded in the petition is a thing on which we have to ponder upon. How to arrive at the amount of notional income of a minor child. Whether can we add what is called as future prospects of life as a separate head. So the first case on the point is Meena Devi versus Nunu Chand Mahato. It's a case of 13th of October of last year, reported in 2023, part 1, Supreme Court cases, page number 204. In this case, there was death of a child of 12 years by name Mr. Banki. He was knocked down by a commander jeep at a given place, and he was studying in 5th standard. In this case, the parents of the deceased approached the MACT for grant of compensation. The MACT awarded rupees 1.5 lakhs as compensation. In appeal to the High Court, the same was enhanced to rupees 2 lakhs. In further appeal to the apex court, the award was in the sum of rupees 5 lakhs. So we'll just unfold now on what points the apex court granted 5 lakhs in place of 2 lakhs, which the High Court granted. So in this case, the Supreme Court held that the notional income of the deceased child should be rupees 30,000 per annum, even though as per Schedule 2 to the Revenue Act, it states the same as rupees 15,000 per annum. So Schedule 2 to the Revenue Act, that particular figure of rupees 15,000 per annum was departed by the Apex Court, and Apex Court in this case held that in case of death of a child, we can take into account the notional income of the deceased at rupees 30,000 per annum, including what is called as future prospects. So this 30%, this rupees 30,000 per annum includes also what is called as future prospects of life. And in this case, the Apex Court applied the multiplier of 15 and awarded in all rupees 5 lakhs as compensation. One more point is, in this case, the claimant had claimed only rupees 2 lakhs as compensation. The Apex Court held that there is no bar for the tribunal or the court to award more amount of compensation than what is claimed by the claimant in his or her petition. So the Apex Court awarded rupees 5 lakhs in place of 2 lakhs claimed by the claimant in this case, based on its earlier decision in Nagappa versus Guru Dayal Singh, that is 2003, part 2, SCC, page number 274. So in this case, the Supreme Court enhanced the amount of quantum of High Court of Jharkhand from rupees 2 lakhs to rupees 5 lakhs. The MACT had awarded rupees 1.5 lakhs. The Apex Court held in this case that we can take into account the notional income of the deceased, a child of 12 years, at rupees 30,000 per annum in place of Schedule 2 to the Motor Vehicles Act. So with this, the second case is Kurvan Ansari versus Shyam Kishore Murmu, that is 2022, part 1, Supreme Court cases, page number 317. In this case, there was death of a child of 7 years in a motor vehicle accident. In this case, the Supreme Court of India took the notional income of the deceased at rupees 25,000 per annum. It adopted the multiplier of 15 and rupees 40,000 was awarded to each of the parents of the deceased. Father and mother of deceased were awarded rupees 40,000 each as loss of consortium, and the total amount of award was rupees 4.7 lakhs. So in this case, the Apex Court took note of rupees 25,000 as the notional income of the deceased. In this case, the rider of motorcycle did not have license to drive the motorcycle, and the insurance policy of the motorcycle was in force when the accident occurred. The Supreme Court held and asked the insurance company to pay the amount and recover thereafter from the owner of the vehicle by invoking the principle of pay and recover. So in this case, for death of a child of 7 years, the Apex Court granted 4.7 lakhs. The MACT had awarded rupees 2.2 lakhs, and in appeal, High Court of Jharkhand had awarded 2.4 lakhs, and the Apex Court enhanced the same to rupees 4.7 lakhs and awarded separate amount regarding loss of consortium to the parents of the deceased, and it took into account what is called as the income of the deceased at rupees 25,000 rupees per annum. So, see the range of quantum of compensation depending upon age of the deceased. The third case law of the Supreme Court on this point is the case of Rajendra Singh versus National Insurance Company. This is 2020, part number 7, Supreme Court cases, page number 256. In this case, there was death of a 12-year-old girl in a motor vehicle accident. So in this case, the question was, what was the multiplier which the MACT should adopt or apply? Number 2, what was the income which the MACT can notionally compute to arrive at the amount of compensation? So in this case, the apex court awarded rupees 2.95 lakhs as compensation in place of the award of the MACT and High Court, which was at a lower sum. So the apex court adopted a multiplier of 50 and took notional income at rupees 18,000 per annum and arrived at rupees 2.95 lakhs as compensation. So, death of a girl of 12 years, the apex court awarded 2.9 lakhs, 2.95 lakhs about 3 years ago. The first case of death of child of 12 years, the Supreme Court awarded in the last year rupees 5 lakhs. So, over a span of 2 years or 3 years for death of a child of 12 years, in the first case of Meena Devi, the amount awarded was 5 lakhs. In the case of Rajendra Singh, the amount awarded is rupees 2.95 lakhs. So, with this, the apex court in this case observed that we cannot calculate mathematically what amount the deceased child would have earned if he had lived and pursued some vocation at a future point of time. So the next important case law on the point is Kishan Gopal versus Lala and others. That is 2014, part 1, SCC, page 244. In this case, there was death of a boy of 10 years in a tractor trolley accident on account of rash driving of driver of the tractor trailer. And this, as per the pleadings, the deceased was assisting his parents in carrying out operations of agriculture of the lands owned by the family. In this case, the Supreme Court adopted multiplier of 15 and took the notional income of the deceased at rupees 30,000 and it added other heads of compensation. Half lakh was awarded towards loss of love and affection, etc. In this case, for death of a child of 10 years, the apex court awarded rupees 5 lakhs as compensation. It's a case of 2014. The award is rupees 5 lakhs for death of a child of 12 years of 10 years in a motor vehicle accident. So my point is how to keep in mind which important decision of the apex court applies to a case before us involving a case of death of a minor. We can quote before the law courts, the case law of Kishan Gopal of 2014, which I told just now, or also the case of Meena Devi versus Nunu Chand Mahato, which is the first case which I just discussed with you. With this, the next important case law of the apex court is National Insurance Company Limited versus Kusuma, that is 2011, part 13. Supreme Court cases, page number is 306. How to assess compensation for a child in the womb of the mother is a question which baffled the trial court, the high court, and also the apex court. A child in the womb, which is not yet delivered by the mother, in this case, whether the claimant mother can claim from the tribunal what is called as compensation for death of a stillborn child. In this case, the claimant was 30 weeks pregnant. She was traveling in Karnataka in a bus from a place called as Sulya to Puttur, both in district Mangalore, South Canara, in our state. And on account of the accident, there was severe injury to the child in the mother's womb. The mother was 30 weeks pregnant. So she moved the MACT at Mangalore for grant of compensation, which awarded her rupees 60,000. Then she appealed to the High Court of Karnataka, which awarded to her rupees 1.8 lakhs. And then after, the matter was taken to the apex court. The question is whether the apex court confirmed the award of the High Court or enhanced the amount to any higher amount of quantum is the question with which we are concerned. In this case, the apex court held that for loss of unborn child of 30 weeks in utero, the award of High Court was confirmed by the apex court. The apex court held that rupees 1.8 lakhs is the quantum of compensation which the mother of the deceased is lawfully required to be given. So, delivery of stillborn child by the injured claimant was awarded by the Supreme Court rupees 1.8 lakhs as compensation. So, in this case, the apex court held that a child in the mother of womb is practically a child which is in fact born, and the High Court decision was affirmed by the Supreme Court of India in this case, and rupees 1.8 lakhs was awarded as compensation. One more point is whether loss of future prospects on account of death of a minor can be awarded or not is a question with which we are concerned. We got on this point the case law of P.K. Malik versus Kiran Pal, that is 2009, part 14, Supreme Court cases, page number 1. In this case, the Supreme Court held that the MACT should award in case of death of a minor in an accident what is called as loss of future prospects. So, the apex court observed that in case of death of a minor in an accident, the tribunal must award some quantum on the heading of loss of future prospects of life. In this case, there was death of children in a motor vehicle accident, and they were all in the age group of 10 to 18 years. The Supreme Court in this case awarded rupees 3.05 lakhs for death of children in the age group of 10 to 15 years, and rupees 3.15 lakhs in case of death of children in the age group of 15 to 16 to 18 years. So 29 school children were traveling in the school bus on account of rash driving of driver of the particular bus. The bus broke the railing of the bridge and the bus plunged into Yamuna River, killing all the 29 children who were traveling in the bus. So the apex court held that the claimants are to be awarded also what is called as loss of future prospects of life and awarded rupees 3.05 lakhs for death of children of the age group of 10 to 15 years and rupees 3.15 lakhs for death of children in the age group of 16 to 18 years. So these case laws indicate that the award of compensation by the trial courts is not consistent with the case laws of the best court which I discussed. In this, the last case which I will touch on the aspect of death of a child in an accident and claim being filed by the parents. The last case is New India Assurance Company Limited versus Satyendra and others. That is 2006, part 13, Supreme Court cases, page number 60. In this case, death of a child of 9 years was awarded rupees 1.8 lakhs by the Supreme Court. In fact, the MACT and the High Court had awarded rupees 4.45 lakhs as compensation. In appeal by the insurance company, the Supreme Court reduced the quantum from 4.45 lakhs to rupees 1.8 lakhs in case of death of a child of 9 years. So, in this case of the apex court, the amount awarded by the trial court and high court was reduced from 4.45 lakhs to rupees 1.8 lakhs. So with this, the next important point which I would like to touch is how to assess the compensation in case of permanent disability cases involving minors. That is the second leg of my discussion on the topic on hand. On this case, we got the case law of the apex court in Abhimanyu Pratap Singh versus Namita Sekon and others. That is 2022 part 8 SCC page number 489. So in this case, the fact in brief are as follows. In this case, the injured Abhimanyu Pratap Singh was aged 5 years and 6 months and was studying in upper kindergarten. He suffered injuries in a motor vehicle accident. He had cerebral edema, brain edema was there. There was fracture of right temporal bone, and there was loss of speech, and his lower limb was completely paralyzed. The doctor, the MACT, the High Court, and the Supreme Court assessed disability of this minor at 100%. In this case, the father of the minor was working as a professor in a college. The mother was working as an IAS officer at a given place. The parents were highly educated They were in good and responsible posts, and they wanted to see that their son becomes also an executive or an officer. So in this case, the MACT awarded rupees 9 lakhs as compensation. In appeal by the claimants, the amount was enhanced to rupees 23.2 lakhs. In appeal to Supreme Court, the amount was enhanced to rupees 51.62 lakhs. Award of MACT from 9 lakhs was enhanced to rupees 23.2 lakhs by the High Court. And from High Court, the matter was taken to the Supreme Court. The Apex Court, in case of disability which is 100% and which is permanent, and in this case, the victim was a child studying in upper KG at a given place, having suffered severe injuries on vital parts of the body, awarded rupees 51.62 lakhs as compensation. So in this case, we'll discuss now on what counts or on what parameters the Supreme Court awarded the amount of 51 lakhs in this case. So in this case, the Apex Court observed that on account of paralysis of both lower limbs of the victim and partial involvement of hands along with the bowel and bladder, it observed that the minor cannot pursue a regular career. The court observed that for assessing future loss of earnings also, the courts must adopt what is called as multiplier method to assess future loss of earnings of minor also. The courts must adopt the multiplier method, that is what is held by the Apex Court in this case. One more point is with regard to the headings on which the court can award compensation in case of disability to a minor. At para 19 of the order, the Apex Court observed that in every case of injury involving disability, more so for a minor, the court must award separately. Number one, for loss of earnings, loss of future earnings. Number two, to award medical expenses, including future medical expenses under the head pecuniary loss. The third point is to also award attendant charges who take care of the child or the minor in hospital or at home afterwards. The fourth heading is expenses spent for transport, including future transport expenses. So the four important headings in case of pecuniary loss are: number one, loss of future earnings; number two, award of medical expenses of the current and future; third is expenses incurred on the attendants; number four is transportation for the present and for future. On the heading of what is called as non-pecuniary head, we have got three subheadings on which the MACT must give its finding. The first subhead is award separately on mental and physical pain and sufferings in present and in future. So there must be award of separate amount for mental and physical pain and sufferings in the present and future. Number two, award separately for loss of amenities of life, including loss of marital bliss. And thirdly, third head is loss of expectancy of life, inconvenience, hardship, discomfort, disappointment, frustration, etc. So the court must award separately on the pecuniary head and non-pecuniary head. What I discussed about these 7 important subheadings. And in this case, the court held that the earnings of the injured minor was taken at rupees 60,000 per year, namely rupees 5,000 per month was the income which the Apex Court took note of to arrive at the amount of compensation in case of disability of 100%. In this case, the Apex Court observed and applied the multiplier of 18 and arrived at the amount of compensation. The minor, by the time the matter came to the Supreme Court of India, had become an advocate and was practicing at the Supreme Court itself, but with difficulty. The Apex Court in this case awarded separately for future medical expenses, including charges to be paid to the attendants or helpers as the case may be. The Apex Court took note of the health of the injured person and awarded rupees 5,000 per month for 2 attendants as attendant charges for the entire remaining life by adopting multiplier of 18. So rupees 21.6 lakhs was awarded by the Supreme Court of India only for attendant charges. So also the Apex Court awarded 9.72 lakhs as physiotherapy charges for the rest of life at rupees 150 per sitting for 1 hour by applying multiplier of 18. The court also awarded rupees 2 lakhs for use of diaper and for medical checkup. The facts indicated that the petitioner could not control the urine and was to urinate within his garments, and rupees 2 lakhs was awarded for use of diaper and for medical checkup. Rupees 2.5 lakhs was awarded for motorized vehicle for use of the petitioner to move from one place to other place because of disability of both the lower limbs not being of any use to the concerned petitioner. So in all, the Apex Court awarded 51.62 lakhs in place of 28.42 lakhs which the High Court awarded, and the award of MACT was rupees 9 lakhs. So see the difference in award of quantum from the level of the MACT up to the Apex Court. So that is, in the range of 6 times the quantum awarded by the MACT. So on what heads we have to award is indicated by the Apex Court. In this case, at para 19, on which I have spent more time to empower the audience here. The second case is a very important case, Kajal versus Jagadish Chand. It's a case of 2020, part 4, SCC, page number 413. A girl child of 12 years was injured severely in a motor vehicle accident. There was severe damage to the brain of the child. The child was left with very low IQ. The child had severe weakness in all the 4 limbs. The child was required to be on the bed for the entire remaining part of her life. See the trauma which the child was required to undergo. A girl child, Kajal, aged 12 years, was physically made to lie on the bed for the entire life. So in this case, what the Apex Court awarded is the question involved, and what discuss the parameters on which aspects the Supreme Court awarded. So in this case, the Supreme Court observed that we did not take into account the notional income of the injured minor at rupees 30,000 per annum, but took in this case the minimum wages of rupees 4,846 per month and took it as what is called as monthly wages which the petitioner would have earned in due course of time after she became a major. So the appeals court took note of the minimum wages of the state of West Bengal of the concerned year. That one was taken as the base to arrive at the amount of compensation. And for that minimum wage of 4,846, the appeals court added 40% as future prospects. And the amount was taken at rupees 6,784 as future loss of earnings. It took note of the multiplier of 18 and awarded rupees 14 lakhs and odd as future loss of earnings. The court also awarded separately rupees 15 lakhs for parent suffering, 3 lakhs for loss of marriage prospects, rupees 5 lakhs for future medical expenses, 2.5 lakhs for expenses of treatment. So in all, the appeals court awarded rupees 62.27 lakhs as compensation for disability caused to a minor girl aged 12 years. The appeals court observed that in this case, the petitioner's social age is of a child which is 9 months old. So the petitioner, when she suffered accident, was 12 years. In spite of treatment, she could not become all right, and she was required to lie on the bed for the entire life. The appeals court observed that it's a case of a child of a 9 month, and she is to be awarded what is called as just and fair compensation. So the headings on which the appeals court observed the awarded are discussed. At para 5 of the decision, the court observed that in case of injuries, there will be the following consequential losses. Firstly, loss of earnings. Secondly, expenses incurred for treatment, including buying of medicines, transportation, special diet, charges paid for attendant or helpers. Third heading is loss or diminution to the pleasure of life by loss of a particular part of the body or limb. Fourthly, what's called as loss of future earning capacity. In this case, the court observed that in some bills which the claimant had produced, there was no mention of the name of the patient. The appellate court observed that even though there is no mention of name of the patient on the medical bills which he gave to the court can still award compensation, taking note of nature of treatment which the petitioner was given and seeing the nature of injury suffered by the claimant. So the court observed that limiting the amount of expenses for medical treatment only to the bills which have been paid in the name of the claimant only would be unreasonable. So it told that we can also take note of the bills for buying medicines, even though they do not contain the name of the patient. In this case, the appeals court also observed that 40% of minimum wages be added as future prospects, and the multiplier in this case was adopted at 18, as I told you just now. So the appeals court in this case allowed the appeal of the claimant, awarding rupees 62.27 lakhs in place of 25 lakhs and odd awarded by the High Court. So with that, the next important case law of the Apex Court on this aspect is Anu Banamara versus IFCO Tokyo General Insurance Company 2020 Part 20 SCC page number 632. In this case, there was amputation of wrist with 55% of disability of a minor child of the age of 15 years. So, a minor child of 15 years, there was amputation of wrist with disability of 55%. In this case, the Supreme Court awarded rupees 7.36 lakhs as compensation. The next case is Rupa Roy versus New India Association Company Limited, that is 2020 Part 18 SCC page number 769. A minor boy of 10 years was injured in an accident. He was orthopedically disabled with post-traumatic paraplegia and weakness in right hand. The doctor opined the disability which is permanent at 70%. The Supreme Court awarded rupees 10 lakhs as compensation. In case of Mallikarjun versus National Insurance Company, 2014, Part 14, SCC, page number 396, there was injury to a child of 12 years in an accident, and there was a fracture of right leg at lower 1/3. There was a deformity of the said right leg. There was restriction in movement of the said right leg out of fracture. The child had 34% disability of right lower limb, and the loss of percentage of the whole body was 18%. The Apex Court awarded 3.75 lakhs as compensation. So in this case, the Apex Court at para 12 of the decision observed that the court must award separately for treatment, for expenses of attendant, etc. And if the disability of the minor is about 10% and up to 30% with regard to whole body, but award rupees 3 lakhs as a separate head. So the Apex Court observed that if the disability is above 10% and up to 30% with regard to whole body, award separate rupees 3 lakhs. Up to 90% of disability, award rupees 5 lakhs. Above 90%, award rupees 6 lakhs. And in this case, the Apex Court laid down these parameters. Disability being permanent with regard to whole body, what award the 3 heads of amounts. 3 lakhs for disability of the whole body up to 30%, up to 5 lakhs disability up to 90%, and above 90% award separate rupees 6 lakhs as future prospects as regards future prospects. That is the relevant para 12 of the decision. So with this, the next point which I would touch is the last case, that is Michael versus Oriental Insurance Company. 2013, Part 18, SCC, page number 774. In this case, a child of 8 years suffered injuries in a motor vehicle accident. He had fracture of right limb, wasting of muscle, weakness in muscle, and doctor opined that there is a 16% disability of the whole body. The MACT awarded rupees 75,000. High Court awarded 1.77 lakhs. Supreme Court awarded rupees 4 lakhs as compensation. So, with these case law on the aspect of death of a minor, injury to a minor involving permanent disability, I have discussed the legal niceties involved, what heads the court must award, on what heads advocates must stress, on what heads also the claim petition should contain important elements. So I have discussed in brief these important aspects. So how to compute compensation for death of a minor or injury of a minor involving permanent disability, how to arrive at the notional income, what is the amount of notional income which you have to keep in mind, and the duty of the court to award separately for future prospects of life in case of death of a minor or injury to a minor involving permanent disability, either partial or total, as the case may be. The rulings indicated the range of award for death of a child of 10 years from 1.5 lakhs to 1.5 lakhs to 5 lakhs as per the orders of the Supreme Court of India, which I have discussed. In case of disability of a minor, though 100%, the range is from 21.6 lakhs as in case of Abhimanyu Pratap, and rupees 62.27 lakhs in case of Kajal. Both cases been disposed of over a gap of 2 years. So with this, I completed my brief exercise on the aspect of the important topic. And for the knowledge of the viewers, the latest case law of the Apex Court in Siddharam versus Siddharam case, that is 2023 part 3 SCC page number 439. In this case, the Apex Court has discussed how to award compensation in case of death of a person of 19 years. So the petitioner had just become a major. He was 19 years, and in this case, the Apex Court laid down the yardsticks which must be kept in mind. So that case law of Siddharam, that is 2023 part 3 SCC 439 can also be kept in mind by the viewers and all concerned. With this, if I got doubts, you may kindly ask me, and I would be glad to answer those doubts.
Only one question has come, that too on YouTube, which says that how do you evaluate a person who dies in the womb?
Yeah, there the Supreme Court in the case which I told you, a child in the womb, its age is just 30 weeks. For the child, the Apex Court awarded 1.8 lakhs. High Court awarded also 1.8 lakhs, and High Court's award was confirmed by the Supreme Court. In that case, the Supreme Court took note of the fact that the child was well developed, it being in advanced stage of pregnancy, it being a child of 30 weeks in age. One more point which the Apex Court took note of the fact is that the mother of the injured was also injured in the accident, and she also moved the court for compensation. But the fact is, this particular child died in the womb itself, and she was forced to deliver the child. There was induced delivery of the child, and the child delivered was stillborn. And the Apex Court, in view of facts of the case, and since the insurance company did not contend in objections that it's not a child for purpose of grant of compensation, and that point was heard by the insurance company before the Supreme Court of India. The Supreme Court observed that point not urged in the pleadings before the trial court, you cannot urge before the Supreme Court of India. So the amount of award of 1.8 lakhs by the High Court was in total upheld by the Supreme Court. The case is National Insurance Company versus Kusuma, 2011 Part 13 SCC page number 306. The Apex Court observed it as a case of a child only for the purpose of grant of compensation. And even in law also, a child not being born, if was injured while in the womb, and the child getting birth upon delivery and suffering the injury which he or she suffered when she was in the womb of his or her mother. We got a plethora of case law on the point in the aspect of torts that she can sue for compensation for the injury inflicted to her or him when she was in the womb of his or her mother. So that's called as right legal status of unborn person. Unborn person, if injured while in the mother's womb, can maintain action upon his birth, and that is the legal status of an unborn person. That is the aspect of jurisprudence, and we can lay hands on this aspect on the second part of Salmon's jurisprudence. The subtopic name is legal concepts. There we have to see the aspect of these persons. Persons are of two types: natural persons, legal persons, and we have got legal status of unborn persons, legal status of dead person, legal status of what's called as lower animals. So there they discuss, and there they say that a person in the mother's womb, if injured, can maintain action upon his birth against the tortfeasor.
Yes, sir, you have nicely explained. One of the person has said, and we had tried 2 or 3 times recently, though I won't be able to understand. If you can give the gist in Kannada of what you're saying, around in 10 minutes.
What's it?
If you can explain everything in Kannada, though I will not be able to understand, but around for 10 minutes if it can be explained.
In Kannada?
Yeah, Kannada.
Okay. Motor vehicle accidents ಕೇಸ್ಗಳಲ್ಲಿ ಅಲ್ಪವಯವರು ಇನ್ವಾಲ್ವ್ ಆದಾಗ ಅವರಿಗೆ ಮರಣ ಆಗ್ಬೋದು ಅಥವಾ ಅವರಿಗೆ ಪರ್ಮನೆಂಟ್ ಡಿಸೇಬಿಲಿಟಿ ಆಗ್ಬೋದು. ಆ ವೇಳೆಯಲ್ಲಿ ನಾವು ಹೇಗೆ ಈ ಕೋರ್ಟಿನ ಮುಖಾಂತರ ಅವರಿಗೆ ಸರಿಯಾದ ಪರಿಹಾರಧನ ಕೊಡಿಸ್ಬೇಕು ಅನ್ನೋದು ಪ್ರಶ್ನೆ ಇದೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಫ್ ಇಂಡಿಯಾ ಅವರು, ನಾನು ಯಾವಾಗ ಹೇಳಿದೆ, ತುಂಬಾ ಕೇಸ್ ಒಳಗಡೆ ಮೀನಾದೇವಿ ಕೇಸಲ್ಲಿ 12 ವರ್ಷ ಮೈನರು ಅವನು ಈ ಆಕ್ಸಿಡೆಂಟ್ ಅಲ್ಲಿ ಅವನು ಮರಣ ಹೊಂತಾನೆ. ಅವನು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವರು ಈ ಮೀನಾದೇವಿ ಕೇಸಲ್ಲಿ ಅವರು 5 ಲಕ್ಷ ಅಮೌಂಟ್ ಅನ್ನು ಪರಿಹಾರ ಅಂತ ಕೊಡಿಸ್ತಾರೆ ಅವರು. ಈ ನಮ್ಮ ಮೀನಾದೇವಿ ಕೇಸಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವರು 5 ಲಕ್ಷ ಅವ್ರು ಹೇಗೆ ಕೊಟ್ಟರಪ್ಪ ಅನ್ನೋ ಬಗ್ಗೆ ನಾನು ನಿಮಗೆ ಇವಾಗಲೇ ಹೇಳಿದ್ದೀನಿ. ಇದರಲ್ಲಿ ಅವರು ನೋಷನಲ್ ಇನ್ಕಮ್, ಈ ಮೈನರು ಅವನು ಎಷ್ಟು ಉತ್ಪನ್ನ ಅವನಿಗೆ ಬರ್ತಾ ಇತ್ತು ಅದನ್ನು ಅವರು ಈ ನೋಷನಲ್ ಇನ್ಕಮ್ ಅಂತ ನಾವ್ ಹೇಳ್ತೀವಿ, ಅದನ್ನ ಅವರು 30,000 ರೂಪಾಯಿ ಪರ್ ಮಂತ್ ಅಂತ ಅವರು ಆ ಕೇಸಲ್ಲಿ ಅವರು ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ. ಇನ್ಕ್ಲೂಡಿಂಗ್ ವಾಟ್ ಈಸ್ ಕಾಲ್ಡ್ ಆಸ್ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್. 30,000 ರೂಪಾಯಿ ಇನ್ಕಮ್ ಅವ್ರು ಎಷ್ಟಿಗೆ ತಗೊಂಡು ಆಮೇಲೆ ಅವರು ಮಲ್ಟಿಪ್ಲೇಯರ್ ಆಫ್ 16 ಅಪ್ಲೈ ಮಾಡಿಬಿಟ್ಟು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವರು ಈ ಕೇಸ್ನಲ್ಲಿ 5 ಲಕ್ಷ ಅಮೌಂಟ್ ಅನ್ನ ಅವರು ಈ ಮೈನರ್ ಅವರ ಪೇರೆಂಟ್ಸ್ಗೆ ಈ ಕೇಸಲ್ಲಿ ಕೊಡಿಸ್ತಾರೆ. ಸೊ ಇಂಪಾರ್ಟೆಂಟ್ ಪಾಯಿಂಟ್ ಅಂದ್ರೆ ನೋಷನಲ್ ಇನ್ಕಮ್, ಈ ಅಲ್ಪವಿತ ನೋಷನಲ್ ಇನ್ಕಮ್ನ ನಾವು ಲೆಕ್ಕ ಹಾಕಬೇಕು. ಏನೋ ಎಷ್ಟು ಗೆಲ್ತಾ ಹೋದ್ರೆ 15,000 ರೂಪಾಯಿ ಪರ್ ಎನಮ್ ಶೆಡ್ಯೂಲ್ 2 ಮೋಟರ್ ವೆಹಿಕಲ್ ಆಕ್ಟ್ ಪ್ರಕಾರ ನಾವು ತಗೊಳ್ಬೇಕು. ಬಟ್ ಇವಾಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಫ್ ಇಂಡಿಯಾ ಅವರು ಆ ಶೆಡ್ಯೂಲ್ 2 ಆಫ್ ಎಂಇ ಆಕ್ಟ್ ಅನ್ನ ಅವರು ಅಪ್ಲೈ ಮಾಡ್ತಾ ಇಲ್ಲ. ಅದು ಮಾಡಿದ್ದು 1994 ಅಲ್ಲಿ. ಇವಾಗ 30 ವರ್ಷ ಆಯಿತು, ಅದು ಶೆಡ್ಯೂಲ್ ಇನ್ನೂ ಅದು ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿಲ್ಲ. ಸೊ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಫ್ ಇಂಡಿಯಾ ಲೇಟೆಸ್ಟ್ ಕೇಸ್ ಲಾ ಪ್ರಕಾರ ಈ ಇನ್ಕಮ್ ವಿಚ್ ದ ಮೈನರ್ ಕುಡ್ ಹ್ಯಾವ್ ಅರ್ನ್ಡ್ ಅದನ್ನ ಅವರು 30,000 ರೂಪಾಯಿಗೆ ಪರ್ ಇಯರ್ ಅಂತ ಅವರು ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ. ಆ ಅಮೌಂಟ್ಗೆ ದೇ ಮಲ್ಟಿಪ್ಲೈ ಬೈ ದ ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಮಲ್ಟಿಪ್ಲೈಯರ್ ಅಂಡ್ ಅರೈವ್ ಎಟ್ ದ ಅಮೌಂಟ್ ಆಫ್ ಕಾಂಪನ್ಸೇಷನ್. ಈ ತಂದೆಗೆ ಮತ್ತು ತಾಯಿಗೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವರು 40,000 ರೂಪಾಯಿ ಪ್ರತಿಯೊಬ್ಬರಿಗೆ, ತಂದೆಗೆ 40,000 ರೂಪಾಯಿ, ತಾಯಿಗೆ 40,000 ರೂಪಾಯಿ ಅಮೌಂಟ್ ಅನ್ನ ಅವರು ಲಾಸ್ ಆಫ್ ಫಿಲಿಯಲ್ ಲವ್. ಈಗ ಮಗ ತೀರ್ಕೊಂಡ, ಸೊ ಪೇರೆಂಟ್ಸ್ಗೆ ಮಗನಲ್ಲಿ ನಮ್ದು ಪ್ರೀತಿ ಇತ್ತು, ಅದು ನಮ್ಗೆ ನಷ್ಟ ಆಯ್ತು, ಅದಕ್ಕೆ ಅವರು ಲಾಸ್ ಆಫ್ ಫಿಲಿಯಲ್ ಲವ್ಗೆ ಮದರ್ಗೆ 40,000 ರೂಪಾಯಿ, ಫಾದರ್ಗೆ 40,000 ರೂಪಾಯಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವರು ಈ ಕೇಸಸ್ ಅಲ್ಲಿ ಅವ್ರು ಕೊಡಿಸಿದ್ದಾರೆ. ಸೊ ಎಷ್ಟು ಅಮೌಂಟು ಈ ಮೈನರು ಅವನು ಅರ್ನ್ ಮಾಡಬಹುದಾಗಿತ್ತು, ಅದ್ರ ಬಗ್ಗೆ 30,000 ರೂಪಾಯಿ ಅಂತ ಅವರು ಪರ್ ಇಯರ್ ಕ್ವಾಂಟಮ್ ಅವರು ತಗೊಂಡ್ರು. ಆಮೇಲೆ ಬೇರೆ ಬೇರೆ ಹೆಡಿಂಗ್ ಪ್ರಕಾರ ಏನೇನು ಕೊಡಿಸ್ಬೇಕು ಎಲ್ಲ ಅವರು ಕಾಂಪ್ಯೂಟ್ ಮಾಡಿಬಿಟ್ಟು ಈ ನಮ್ಮ ಮೀನಾದೇವಿ ಕೇಸಲ್ಲಿ 5 ಲಕ್ಷ ಅಮೌಂಟ್ ಅನ್ನ ಅವ್ರು ಕೊಡಿಸಿದ್ರು. ಈ ಕೇಸಲ್ಲಿ MACT ಅವರು 1.5 lakhs ಕೊಡಿಸಿದ್ರು. ಹೈಕೋರ್ಟ್ನವರು 2 lakhs ಕೊಡಿಸಿದ್ರು. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವರು ಈ ಕೇಸಲ್ಲಿ 5 lakhs ಅಮೌಂಟ್ ನ ಅವರು ಕೊಡಿಸಿದ್ರು. ಒನ್ ಮೋರ್ ಪಾಯಿಂಟ್ ಏನಪ್ಪಾ ಅಂತ ಹೇಳಿದ್ರೆ, ಈ ನಮ್ಮ ಅಲ್ಬೋಯಿಗೆ ಈ ಆಕ್ಸಿಡೆಂಟ್ ಕೇಸಲ್ಲಿ ಅವನಿಗೆ ಶಾಶ್ವತವಾದ ಅವನಿಗೆ ಡಿಸಬಿಲಿಟಿ ಆದ್ರೆ ಆ ಕೇಸಲ್ಲೂ ಕೋರ್ಟ್ನವರು ಹೇಗೆ ಈ ಅಮೌಂಟ್ ಕೊಡಿಸ್ಬೇಕು ಅನ್ನೋ ಬಗ್ಗೆ ಅವರು ಯಾಸ್ಟಿಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದ್ರ ಬಗ್ಗೆ ನಾನು ಸವಿಸ್ತಾರವಾಗಿ ಈ ನಮ್ಮ ಅಭಿಮನ್ಯು ಕೇಸನ್ನ ಹಿಡಿದೇನೆ. 2022 ಪಾರ್ಟ್ 8 SCC ಪುಟ 489. ಈ ಕೇಸಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವರು ಯಾವ್ಯಾವ ಹೆಡಿಂಗ್ ಅಲ್ಲಿ ಅಮೌಂಟ್ ಕೊಡಿಸ್ಬೇಕಂತ ಅವರು ಕಾಣಿಸಿದ್ದಾರೆ. ಇದರಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವರು ಔಷಧಿ ಉಪಚಾರ ಸದ್ಯ ಆಗಿದ್ದು ಅದನ್ನು ಕೊಡಿಸ್ಬೇಕು, ಮುಂದೆ ಆಗೋ ಅಮೌಂಟನ್ನು ಕೊಡಿಸ್ಬೇಕಂತ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ. ಆಮೇಲೆ ಈಗ ಓಡಾಡೋ ಖರ್ಚು, ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಖರ್ಚು ಅದನ್ನು ಕೊಡಿಸ್ಬೇಕು, ಮುಂದ್ಗಡೆ ಏನೋ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಖರ್ಚಿದ್ರೆ ಅದು ಕೊಡಿಸ್ಬೇಕಂತ ಅವರು ಕಾಣಿಸಿದ್ದಾರೆ. ಆಮೇಲೆ ಆನ್ ಅಕೌಂಟ್ ಆಫ್ ಡಿಸಬಿಲಿಟಿ ಈ ನಮ್ಮ ಅಭಿಮನ್ಯು ಕೇಸಲ್ಲಿ ದ ಪಟಿಷನರ್ ಕ್ಯಾನಾಟ್ ಮ್ಯಾರಿ, ಅದಕ್ಕೆ ಲಾಸ್ ಆಫ್ ಮ್ಯಾರಿಟಲ್ ಲೈಫು, ಲಾಸ್ ಆಫ್ ಅಮ್ಯುನಿಟೀಸ್ ಟು ಲೈಫ್, ಲಾಸ್ ಆಫ್ ಎಂಜಾಯ್ಮೆಂಟು, ಅದಕ್ಕೆಲ್ಲ ಅವರು 4 ಲಕ್ಷ ಅಮೌಂಟು ಅವ್ರು ಕೊಡಿಸಿದ್ರು. ಸೊ ಈ ಕೇಸಲ್ಲಿ MACT ಕೊಡಿಸಿದ್ದು 9 ಲಕ್ಷ, ಹೈಕೋರ್ಟ್ ಕೊಡಿಸಿದ್ದು ಅಮೌಂಟು 23 ಲಕ್ಷ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೊಡಿಸಿದ್ದು ಅಮೌಂಟು 51,62,000. ಅಂದ್ರೆ ಯಾವ್ಯಾವ ಹೆಡಿಂಗ್ ಮೇಲೆ ನಾವು ನೀಟಾಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಹೇಗೆ ಈ MACT ಆಗಲಿ, ಹೈಕೋರ್ಟ್ ಆಗಲಿ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಗಲಿ ಈ ಸರಿಯಾದ ಅಮೌಂಟ್ ಬೇರೆ ಬೇರೆ ಹೆಡಿಂಗ್ ಒಳಗೆ ಸಬ್ ಪಾರ್ಟ್ ಮಾಡಿಬಿಟ್ಟು ಕೊಡಿಸ್ಲಿಕ್ಕೆ ಅನುಕೂಲ ಆಗ್ತದಪ್ಪ ಅಂತ ಹೇಳಿ ನನಗೆ ಅನಿಸ್ತದೆ. ವಿತ್ ದಟ್ ಪಾಯಿಂಟ್ ಐ ಡಿಸ್ಕಸ್ಡ್ ಅಟ್ ಲೆಂತ್ ಈ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ಕೇಸ್ ಲಾ ಆಗಿತ್ತು.
Yes, sir.
Okay.
So that was the only request by someone, and you have acceded to that. Thank you, everyone. And thank you, sir, for sharing your knowledge. And we will be all viewed for the World Cup tomorrow.
Yeah. In fact, tomorrow I think we had a plan to fix it, but tomorrow being match of the cricket at Ahmedabad, I think today we had a good time to spend. I thank all the viewers. I thank all the participants. And, I'm very sure that what little I have shared with you will be of use to some extent in the law courts. So thank you very much. Good night.